Good afternoon. I'm George Galindo. I will chair this panel. It's an honor, a great honor. Unfortunately, I couldn't be with you in Washington, D.C., but I'm sure we're going to have a very interesting and exciting discussion on this panel. Well, as you know, the name of the panel is Non-Western Approaches to International Law. And this is a kind of panel that tries to discuss very interesting topics from different perspectives, from different doctrinal perspectives, especially taking into account many new approaches to international law, such as TWAIL, feminism, and legal pluralism, and others. So it's, as I said, it's a great honor to me to chair this panel. And I would like to present our panelists. I would just, it's important to clarify that all panelists will have first 6 minutes to present. And then we will proceed into a general discussion of 15 minutes. Within the panelists, I will try to coordinate the discussions. And then we will have 10 minutes for audience questions, and then closing of the panel. So it's a pleasure to me to present you first Francisco José Quintana from the University of Cambridge. Francisco, you could start. You have 6 minutes. Thank you very much.
Thank you very much, George, Alejandro, organizers, co-panelists, and everyone joining us today. As I prepared for this panel, a passage from the novel Formas de Volver a Casa by Alejandro Zambra came to mind. The protagonist reflects upon conversations from his university days. His classmates recounted tales of death, family, and politics in Chile under Pinochet. The protagonist did not have a personal experience to share with them. However, he refrained from telling the pertinent but personal story of his neighbor. The protagonist explains, "I knew little, but at least I knew that. No one could speak for someone else. That although we might want to tell other people's stories, we always end up telling our own." This passage infuses my account today. What has come to stand for Latin American approaches to international law too often resembles a generalization of very particular perspectives. Perhaps one could say our understanding has been shaped by people telling other people's stories. I want to problematize 3 myths about Latin American approaches to international law. First, let us consider what could be called the myth of anachronistic formalism. This is the idea that there has been a Latin American inclination for impractical legal arguments stemming from an overzealous defense of state sovereignty. This myth is both prevalent and long-standing. In the 1959 ACIL annual meeting, US professor Aaron Thomas provided an illustrated expression of this view. He contended, using his terminology, that the absolute doctrine of non-intervention championed by Latin Americans rendered the legal process incapable of protecting the basic goods of the inter-American community. Thomas was doing a few conventional moves. He portrayed Latin Americans as formalists. He depicted this formalism as anachronistic, arguing that it emerged in response to 19th century interventionism. And he advocated for pragmatic deformalization instead. Similar expressions can be found today, for instance, in NGO reports on Latin America that speak about the archaic principle of non-intervention. This myth can be contested in multiple fronts. To begin with, the portrayal of an unyielding formalist obsession among Latin Americans is inaccurate. For instance, Latin American states co-created the inter-American system, arguably the first regional legal political system, evidencing a will to cooperate to advance the common interests of the inter-American community. Admittedly, Latin American jurists and diplomats have performed a balancing act between their requests for cooperation and what could be called defensive legal formalism. But this has rarely been an anachronism. Throughout the 20th century, for instance, many Latin Americans deployed principal legal arguments to resist the abuses of collective action or the adoption of international standards against their interests. Yet, the myth of anachronistic formalism persists. I'll call the second and related understanding that I want to problematize the myth of no real difference. Again, the ACIL annual meeting serves as a starting point. In 1986, Argentine international lawyer Hugo Caminos argued, and I quote, "The Latin American approach to law is fundamentally a restatement of Western legal theories and ideas, particularly of European origin." He then extolled certain universal international legal rules with origins in Latin America. This epitomizes the contributionist approach of many Latin American lawyers. Contributionism does not challenge international law's claim to universality, rather it legitimizes it by depicting the discipline as an assemblage of global inputs, contributions. Contributionism obscures the extent to which other Latin American actors have criticized and sought to change central aspects of international law. Consider, for instance, the project to codify an American international law in the early 20th century, most often associated with Alejandro Alvarez, or the projects to change international economic law associated with the structuralist economics of the UN Economic Commission for Latin America, or the work of various Latin Americans in the United Nations between the 1950s and the 1970s. Among them was Mexican Jorge Castañeda, who argued that, in his words, in the vast body of law having to do with the responsibility of states, the rules now in force were not only created independently of the interests of the small states, but even against their desires and interests. The emphasis on contributions and the understatement of difference failed to properly capture many Latin American visions, experience, and projects. Finally, there is the more recent myth of the historical centrality of human rights. The general idea is that human rights, as we know them today, have long defined Latin American approaches to international law. The myth connects to some of the points I have raised. It's a contributionist account, so it celebrates Latin Americans' role in the construction of a global project it fails to challenge. It's frequently set against the strawman of formalism. Sovereignty, state consent, rules are all made enemies of a story that calls for action and policy. And it's historically simplistic. The regional codification and institutionalization of human rights were part of broader struggles over the legal ordering of regional geopolitical and economic relations. To be sure, human rights arguably define Latin American approaches today, with important virtuous consequences. The myth of historical centrality consolidates their present centrality, but it does so at the cost of obscuring other concerns in the past and in the present, as well as the need of developing alternative languages and mechanisms to address them. Let me conclude by stressing that a central dimension in all this is the political economy of knowledge production. Funding decisions made and collaborative projects designed in the North Atlantic determine which stories get to be told. So I appreciate this panel's approach today as an open-ended horizontal conversation, and I look forward to the discussion. Thank you.
Thank you very much, Francisco. And now I would like to give the floor to Professor Lauri Malkso from the University of Tartu. Professor Malkso.
Thank you very much. And I see it as a sort of central question of this panel. It relates to the universality of international law as opposed to also regionalism and regional tendencies. And I will look in my comments, try to grasp a little bit about the situation of Russia in this framework. And I can bring in a sort of late-breaking element because today Russia adopted its new foreign policy concept. I had a quick look at that, and I was curious what has changed in terms of how they talk about international law, and it is still very interesting that, for example, in such a document, they continue talking about international law a lot. That international law is important. Russia wants to protect international law. And I think it just reiterates my sense that I have had for years that we are having globally a kind of dialogue des sourds, the dialogue of the deaf, that basically different regional hegemons might have different perspectives of international law. They just don't want to necessarily maybe listen to each other. And this concept characterizes Russia not as a usual state, but it calls it state civilization. And generally, it's a kind of red thread that goes through Russian international legal thought. In fact, without sometimes being aware of it or mentioning it, I think Russian theory of international law, at least since the early 20th century, has been what the German scholar Carl Schmitt would have called Großraum theory. So it's Russia as a hegemon in Eastern Europe, in Eurasia, and somehow it has a legitimate claims over neighboring countries, such as currently Ukraine. So my sense is that a Russian approach to international law is also a non-Western approach, one of the examples of non-Western approaches, which means that we should not automatically romanticize all non-Western approaches because Bucha and Mariupol is also then Russian approach to international law in some ways. And of course, if you this is not a history conference and there is no time for that, but if one zooms a little bit, takes a longer perspective on Russia's history and Soviet history of international law, then a bit provocatively, I might ask whether international law has ever been universal. Because when one reads the late 19th century, early 20th century works, they of course proceed from this European assumption of civilized versus uncivilized. When the Soviets come, then authors like Korovin and Pashukanis in the 1920s say that the unity of humankind has broken down for ideological reasons. Soviet Russia, Soviet Union has its own sphere, its own circle of international law. Even during the later stages of Cold War, a lot is talked about socialist international law as they don't deny the universality of international law, but they say that there is a special kind of international law between socialist countries. For that purpose, they justify, for example, the intervention to Czechoslovakia in 1968, actually in contradiction with the UN Charter. So again, a kind of collision between universalist readings and regional readings of hegemony in international law. And my final thought in this regard is that I think it is inevitable that any bigger country's approach to international law would also be co-shaped by how it practices and experiences law domestically. And Russia's particular difficulty has in that sense been to create checks and balances. Russia's system of governments throughout history has been authoritarian, and I think if the executive is not constrained, it can basically use law as a political tool. It can change interpret law one day in one way and then change that interpretation. And we can see it also a little bit in the international legal practice of Russia in the last couple of decades, when sometimes it is state sovereignty and territorial integrity that is emphasized, and in another context it is suddenly right of peoples to self-determination, which is, by the way, an argument that Russia tried to put forward in defending its action against Ukraine. So I'll stop here. Thank you.
Thank you very much, Professor Marzo. So I'd like to give the floor to Professor Nitina Tsovala from the Australian National University. Nitina, please go ahead.
Thank you very much, Professor, and thanks to my co-panelists. So I want to start with reminding you an incident that happened maybe less than 2 months ago, right? When the US and China were locked into a heated debate about the balloon, right? And whether the balloon could be shot down and what was the purpose of the balloon. Was the balloon the victim of force majeure, etc.? And many of the people who tried to calm down the situation, to de-escalate the situation, one of the arguments that were circulating was like, don't worry, it wasn't headed for a continental US, it was just going to Guam. Now, I think de-escalating the situation was imperative, obviously, but I'm quite worried about the just going to Guam. Because, and I could talk, of course, about the ongoing colonial relations between the US and Guam, but what particularly worries me here from the perspective of international lawmaking is this, kind of turn of phrase as indicative of a broader imaginary, of course, of the people of Guam as expandable, but more broadly of the Pacific as an empty space, pretty much, that is just the background for geopolitical competition between the great powers, or let's say for trade, or the relationship between geopolitical competition and free trade. And I am someone who's not a Pacifica scholar, but I do live by the Pacific in Sydney. So in that respect, I don't want to talk for the Pacific, but I want to think with Pacific legal scholars about what it would mean if we start thinking international law, and especially the international law of statehood, if we stopped treating the Pacific as an empty space for geopolitical competition. What I do have in mind here, of course, is the unfolding debate, which is both academic, but it has obviously a policy and a life implication about the question of state continuity in light of rising sea levels and the very real possibility that within the next 30 to 50 years, a number of low-lying states, especially but not exclusively states located in the Pacific, are going to lose 100% of their territory, or their territory is going to become uninhabitable to the extent that actually everyone will have to migrate out. There is a number of ways one could make this argument in support of the continuity of the legal personality, or not the legal personality in particular, of statehood in the cases of Pacific Islands that are endangered to lose their territory. For example, one very traditional argument in light of what Laurie was saying, holding on to the universality, or at least to the purported universality of the canon, it would be just say, well, listen, the preconditions for state continuity are not the same for the creation of states. We have already accepted that a state might lose unified government, but nevertheless remain a state for the purposes of international law. Somalia, Syria, a number of instances, and therefore losing your territory or your population to relocation should be treated by analogy in the same way. Hence, legal personality continues. And I think there is a lot of value to this argument. I think that's a good, solid argument. What I find a bit both conceptually and perhaps politically limited with this argument is that it behaves a little bit like we know what territory means in international law. And we would all understand when the territory is lost in international law. What I have in mind here is three presumptions made about territory, and I'm going to argue that all these three presumptions are fundamentally political, and they are fundamentally Eurocentric. The first one goes directly back to the Montevideo Convention, and of course the customary iteration of the Montevideo Convention criteria, and it is what we accept pretty much as a given, which is territory as a criterion is distinct enough from government. And that relies on the idea that territory pretty much means exactly the same thing as space, right? What is territory is that we exist in space. I don't think this is the case, and of course to those in the room who are perhaps political geographers, this will sound like, obviously, that's a stupid argument, but hold on with me. In the sense that my argument there is that space only becomes territory and only became territory in particular moments of time when the powers of the modern state were employed upon territory. What makes place or space territory is being governed by states, being measured, being, That's 6 minutes. Being measured, being mapped, and so on and so forth. The second thing, and I'm going to conclude because I'm running out of time, is that territory means primarily land. And as the ICJ said in the North Sea continental shelves case, land dominates the sea, right? You have sea territory because of you have land territory and certain rules flow for that. And finally, that territory needs to be physical and not artificial. This generally comes, in my view, from a very bad reading of what UNCLOS says about artificial islands. Trying to bring the conversation back to Pacific approaches to international law, each one of these presumptions, and especially the first two, and especially the idea that land dominates the sea, have been politically and ontologically alien to Pacifica people. The fundamental continuity between land and sea without any hierarchical relationship between the two has structured Pacific life long before the colonial encounter, but even during the colonial encounter, with very limited periods of limitation due to punitive measures imposed by colonial powers against traveling between different islands. And therefore my argument is that apart from all other arguments that one might make in support of state continuity, if you're so inclined, of course, one would be to start thinking to what extent Eurocentric notions of law and of space have formed our thinking of what the 4 criteria in the Montevideo Convention mean, and perhaps that this is a moment to start thinking that these conceptions not only don't have proper authoritative grounding, the actual authorities for them are very, very limited. If you try to see where this artificial thing comes from, there is a Hamburg case and there's James Crawford. There isn't much more than that.
Tina, sorry.
Yes, sorry. And I'm going to conclude. Okay. Yes, pretty much that's it. And first, and secondly, that the way we've been thinking about the Montevideo Convention is not fit for purpose anymore. Thank you.
Sorry, Tina.
No. I'm sorry.
A very interesting discussion, but in any case, we have to go on. I would like to give the floor now to Professor McAlvany from the University of Leeds in the UK.
Hi, everyone. Good evening from cold and rainy Leeds. Thank you to Dina and Alejandro for the invitation to participate in this panel. So my presentation will build on the theme of the panel, which is non-Western approaches to actually need to set my timer. Non-Western approaches to international law. And I'll be looking at TWAIL and intellectual property and trying and contemplating on the idea of restorative justice as a way to remedy the mess that was a global response to the COVID-19 pandemic, and even as we prepare for next pandemic, as many health scientists have warned us is most likely going to happen sooner than we think. We all know what happened during the COVID-19 pandemic. We also how intellectual property was used by both pharmaceutical companies to hoard knowledge, to block competition, and to maximize venue. We saw how pharmaceutical companies in cahoots with their national governments were able to pursue self-interest and greed, profit over human lives in the distribution and access to COVID vaccines, therapeutic diagnostics. For many TWAIL scholars, what happened during the COVID-19 pandemic, the global response, it's not new for this particular school of thought. The IP regime and the attendant inequalities are a continuation of asymmetrical power relations rooted in historical racialized processes such as slavery and colonialization, and its post-colonial legacies that continue to perpetuate racialized hierarchy. So for TWAIL, basically, this and I mean for the uninitiated, TWAIL is both an intellectual and political movement that seeks to understand the history and structure and processes of international law from the perspective of countries in the global south. Ultimately, what TWAIL tries to do is to foreground that which the West is unwilling to theorize or confront, which is the correction of the sanitized and whitewashed pictures of modern global order. And to also challenges the delusions of Eurocentric international law. And if we see trade, if we understand it this way, we'll begin to see that what happened during the COVID-19 pandemic, it's not new. What happened is basically the system functioning as it was created to do. So now the question is, how do we remedy this unfortunate situation in preparation for the next pandemic? One of the most important attributes of TWAIL is that the movement has given us the language to adequately theorize not only historical and transnational sources of injustice, but also the movement has persistently highlighted spaces of transitional justice projects championed by coalitions of both racialized minority and indigenous communities located in the global south. So if we go by the TWAIL analogy, as I quickly brushed over because I did not have time. So it opens up to an analytical frame of restorative justice approach, which seeks to restore relationship to rightness. That is the notion of creating healthy relationship where they were absent before. A restorative justice approach seeks to repair what is broken, to compensate victims for the harm done, and to reconcile relationships, right? In other words, it aims at restoration, compensation, reparations, where all parties with a stake in the serious dispute come together to resolve it collectively. To be sure, the idea of restorative justice is not new to TWAIL. It has been practiced by many grassroots and indigenous communities in the global south. But in practice, the kind of justice pushed forward by TWAIL involves getting to the truth of the issue, right? Involves understanding the root causes of the issue. It involves acknowledging actions of failure to act that caused harm and injuries, and then instituting frameworks to avoid future similar problems. So in this particular case, in the case of the COVID-19 pandemic global response, it allows us to, it provides a language to name the neglect, the harm that was caused by the systematically inequitable rollout of vaccines, tests, and treatment for what it truly was, if we're being honest, which is a crime against humanity, right? So for instance, so why the pandemic devastated all countries around the globe, countries in the global south, especially women and children, we have bore the disappropriate burden of the of the injury or the harm caused by the pandemic. So just to quickly wrap up, a serious call for a Twailean restorative justice approach demands that we liberate ourselves from the fiction that current global IP law, with its flexibilities and muted waivers, can tackle the question or the problem of unequal access to essential medicines, equipment, tests, and know-how. It demands a new thinking, an understanding that this world and this system as we know it is historically contingent and constructed, and a new way of doing is possible. This world building that TWAIL demands of us requires that we decenter the interest of the interest and the whims of transnational corporations, and in its place will create a world informed by more participatory politics and lawmaking. This would look like creating a system that is not only humanely, economically, environmentally, and racially just, but one that upholds people over property. So this would look like, if you put it in lay terms, this would look like creating a world where creating a forward-looking world, one which aims to prevent future offending via the drastic overhaul of IP regimes and legal codes that propagate racial hierarchies and legacies of colonialism and imperialism. Finally, it also involves imputing a sustainable financial system, right, that provides for appropriately publicly funded research that supports pharmaceutical manufacturing in the global south, and that provides the freedom for these countries, the lower middle income countries in the global south, to pursue research, to pursue the development and democratization of pharmaceutical manufacturing, just so that in the next pandemic, we have a more equitable world whereby access to medicines, to treatments, to diagnostics is not situated or concentrated in the hands of a very few people or companies located in the global north. Thank you.
Okay. Thank you very much, Maka. Now I'll give the floor to our last panelist, Professor Kanle Zhang from the Peking University. Please go ahead.
Thank you, Professor. Thanks to Alexandro and Nitina for the invitation. Privilege to be here. For next 6 minutes, I aim to argue that the display of rivalries between big powers, for example, US, China, is a product of the Western approach to international law. And more importantly, this Western approach purposely shields the legal mechanisms that serve the interests of a small group of transnational elites at the expenses of the masses, shielding this from the scrutiny of international lawyers. The display of rivalries at the international arena has attracted much attention. For example, what Nitina was just mentioning was the balloon, and also the China-US dynamic in international relations more broadly, and the manifestation of that particular relationship in international law taking the form of, for an example, debating around absolute sovereignty, non-intervention versus responsibility to protect. And despite the obsession in what some term as the Chinese approach to international law, I argue that what is termed as the Chinese approach to international law is actually the orthodox European approach. In Nitina's words, the presumptions made about international law from the perspective of the Chinese is that it's Eurocentric. It's a European international law that was universalized in the 19th and early 20th century, the Mestizo international law, as Arnulf Lorca has usefully put it. The profound insistence on the absolute notion of sovereign autonomy, equality, the embracement of positivism and legal formalism, which are at the core of the Chinese approach to international law. And this roots deeply in the European international law and its geographical expansion in the 19th and early 20th century. The Chinese approach, in essence, rooting in the orthodox European international law, is a result of the appropriation of the international legal discourse by the Chinese through faithful learning of international law and believing in the European origin of international law. For an example, the late Professor Wang Tieya, mentor of the leading international lawyers of the People's Republic of China, mentor of my professors when I was a student in China, writes in his monograph, quote, "Modern international law has its origin in Western civilization. It has, however, been expanding to the whole world," unquote. That is to say, for international lawyers to invest in rivalries between big powers, it wrongfully understands the Chinese approach by thinking that there's something particular about a Chinese approach, and it misses the European origin of that approach. And more importantly, for international lawyers to invest in rivalries between big powers, it overlooks the actual and effectual distributive outcomes of the international legal mechanisms that is, it shows the legal mechanisms that are serving the interests of a small group of transnational elites at the expenses of the masses from the critical engagement of international lawyers. In other words, small groups of people and industries benefiting through international legal arrangements have easily escaped from the attention of international lawyers. For an example, the coercion, the distributive effects as a result of the coercion, which are all built into the legal infrastructure of international finance, which is what I work on, have not attracted enough attention of international lawyers. The seemingly technical and complex legal arrangements involving sovereign debt, involving the payment system, the banks, the rating agencies, and more are the ones effectively serving the interests of a small group of transnational elites. And perhaps even more importantly, a combination of an orthodox European international law with the effect of portraying rivalries at the front and center and shielding transnational legal mechanisms that are actually serving the interests of the few, and B, the transnational elites continuously benefiting from these legal arrangements. So this combination seems to have captured international legal thinking to an extent that non-Western approaches to international law, for example, the one my fellow panelists have nicely articulated, questioned, might be facing challenges when it comes to practical terms of materializing these approaches in existing orthodox Western international law. So where to go from here? I suggest that the non-Western approaches could well thrive in the institutions and more broadly, the discourses of the orthodox Western approach. What do I mean by this? In the 19th and early 20th century, the Western and non-Western individual international lawyers and approaches to international law interacted. That's what Arnulf did in his monograph. And together, the Western and non-Western international lawyers expanded the geographical location of the European international law. This tells us that today, perhaps the efforts of international lawyers promoting non-Western approaches and thus adding bricks to the plurality of international law might well, through our interactions with the singular orthodox Western international law, lead to an international law towards the direction of justice. The space for non-Western approaches is perhaps exactly at the same institutions and classes and intellectual harbors of the orthodox European international law. And for that reason, I'm grateful that we have a panel on the non-Western approaches to international law at the ACL conference. Thank you.
Thank you very much, Professor John. Now we should proceed to a panel discussion, a short panel discussion. I would like just to start putting some issues that I think they are common to all presentations. It's interesting, and the order of the presentation was quite interesting because, first of all, I'd like to emphasize what Francisco just said about the political economy of knowledge, which means that non-Western approaches needs to be more visible. And this is the first point we should maybe discuss about. And this has to do with something that Professor Matzo, but also Professor John just said, that we don't need to romanticize even Russian approaches to international law or Chinese approaches to international law, because in some ways they can be, if not the same, but very close to European approaches. So the need for them to be more visible is also to criticize them. So the critical movement, the idea of critical international legal thinking is also the idea of criticize critical legal thinking. It's like a meta critique, an exercise in meta critique. And I would like also to engage the presentations from Nitina and also Amaka. In the case of Nitina, I think we need also to make more visible these non-Western approaches, also to criticize the idea of traditional statehood, or specifically the idea of the presumption about the territory, state territory being physical. And also what Amaka just said, that TWAIL, if you make TWAIL more visible, we can also take the language TWAIL provides to international law, for example, to engage better in issues such as the pandemic and how to deal with future pandemics. So in this view, it would be very interesting to hear from the panelists how we could engage all those issues. I know it's very difficult, and we have just, I think, 10 minutes. But in any case, please feel free to discuss on this or other issues, but we don't have much time, unfortunately. Please go ahead on that order, please, Francisco.
Thank you very much, George, and to everyone. This is really exciting. So a few quick points on the issues you have raised and my panelists have raised as well. So on the political economy of knowledge production, perhaps in the more informal setting of conversation, I think yeah, we need to be very practical, right? So what does non-Western approaches to international mean, or how does that conversation mean? If we receive an invitation to speak in this panel and we are asked for our inputs, and then the invitation is open-ended, then we will hear different things about China, about Latin America, about Russia, about the Pacific, about Africa. And some other perspectives. Whereas if you receive an invitation to contribute a chapter to an edited volume whose introduction has already been written, then there is a reproduction and a reification of traditions and myths and conceptions which might be wrong or not, but probably simplistic or just part of the story. So that's one thing, and it would be interesting to think how to replicate this kind of thing more, although, of course, Professor Angi gave a very interesting account of the development of TWAIL yesterday as a network. In terms of the need to criticize non-Western approaches, I agree, and that would force us to incorporate positionality, right? So from which perspective are we engaging the non-Western approaches? So I will speak from what I know about Latin America, and so I completely empathize with Laurie's concern about hegemonic regionalism. I would be interested in knowing, well, how does he think we can deal with hegemonic regionalism? Because an obvious tool, I mean, in that particular context, would be to resort to the universal, right? From the Latin American perspective, one thing that I think is particularly valuable, and it's not a perspective that has been particularly recognized, is the balancing act, right? So the best or the most politically savvy approaches in the 50s and the 60s among Latin Americans was conducting this balancing act between not foreclosing the universal, because it was a mechanism to check an inter-American system from becoming too, and eventually it did become too dominated by the US in the global Cold War, but at the same time regionalism opened the way for change. Or it seemed so in many cases. So cooperation, I mean, if we want to change the meaning of the doctrines of state continuity or access to technology, well, it seems to me that working at the regional level can be very helpful. And just to conclude, there's this idea where regionalism can either harm or strengthen the modes of global governance. Those are the dominant perspectives. And I think it would be much more productive to think about regionalism as a possibility of shaping a different international legal order, more or less. Thank you.
Okay, Laurie, next one, Professor.
Okay, I have a kind of random thought, which I will add to that, and that is, how can we better, as international lawyers, take into account the role that regionalism and regional approaches play in the context of international law? I think one of the starting points could be that not everything of relevance to international law happens in English language. That is, being in Washington, D.C., this is kind of provocative to say, but I think that once one does not include or have those bridges to those other, especially non-West European languages, the understanding of those differences that might actually exist in the world, even in the understanding of international law, will never be somehow sufficient. In that sense, I think it should be a kind of job requirement, especially for professors doing scholarship, that one reaches out to other languages. I think in the 21st century also to non-West European languages. Of course, in the history of international law, we have had this plurality of West European languages dominating the field, English and French. But I think that in the future, if I could rewire myself and start from the beginning, I would put in my brain also the knowledge of Chinese and Arabic beside Russian, what I have.
Thank you very much, Laurie. Now, Nitina, please go ahead.
Thank you, Professor. Yeah, so I think in a sense, this battle about the continuity of states in the light of climate change shows, as you implied, the value placed on continuous statehood, right? So there is parts of the bibliography especially that are saying, oh, you know, maybe there should be some other form of legal personality. Look at the Holy See, look at the Knights of Malta, whatever. This is a position held by precisely 0 Pacific states, because I think Pacific states know that, you know, the only thing worse than having a state is not having one, and not being given even the very layered and conditional upon power of transnational corporations, but still not being given the very particular rights and privileges that come with statehood in international law. So in a sense, I think that also places a lot of debates that I think we all agree have outlived their importance, but I think especially all these debates that sovereignty is so 1880s and whatever, I think it places them in a very particular light, because those who are actually in danger of losing statehood, they seem to be holding on to it. And I would say for good reasons, right? So I think a lot of things from the 90s and early 2000s could be reread in light of the existential crisis of climate change. And I'll leave it there.
Okay. Professor Makavani, please, go ahead.
With the non-Western approach to international law, and with all the conversations we're having now, it shows a thinking that we not only do we need to make more a non-Western approach even more prominent, but I also think for this prominence to happen requires us to requires a certain boldness, right? I always say that those who employ and deploy critical approaches, specifically TWAIL, in praxis, in their teaching and scholarship, have a certain sort of bravery, because this is not what is mainstream, right? And so for that bravery, that bravery is required. And not only that, it also then needs to be the paradigm needs to, for example, the restorative justice paradigm that I just I discussed in my presentation would also need to embody the principles of inclusivity, the principle of balance of interest, of problem-solving orientation, right? So it will involve us doing what we are not comfortable, what we are not doing. It involves us imagining a totally whole new, different world order that most people are not comfortable, are not used to, and most people are scared to think of what do you mean by that. And the various pockets of international lawmaking in the global south, be it in Latin America, be it in Africa, be it in Asia, requires us to think of a whole new different world. So just to wrap up and to also to bring in the theme of this panel, which is centering and making more pronounced the non-Western approaches. For that to happen, in addition to even learning new languages, as Professor Lori mentioned, it also requires us to have a certain bravery, right? And that bravery is going to come with a lot of pushback. We saw that during COVID, when India and South Africa was asking for waiver, which again in international making was a new thing, right? So it will require pushback, but that doesn't mean we should stop. That once we get the pushback, we should stop. Centering and making more prominent these new forms of international law, right? This is basically what we need. This is the impetus we need to make it more center stage in international law arena.
Okay, thank you. And finally, Professor Conley, Jean?
Yes, thank you. Perhaps I could quickly reflect on what I understand as the non-Western approach. So for me, the non-Western approach is not about some specific approaches to international law, but rather about reflecting on the traditional ways and modes of engaging with international law, and to unravel the hidden secrets of the orthodox ways and modes. So very similar to what, for example, Francisco was saying in terms of the formalism built in the Latin American endeavors in the struggle of international law, to put broadly, and Laoli's idea of not to romanticize the Russian approach, the Chinese approach, or whatever approach, and Nitina's work of idea of questioning the traditional orthodox understanding of statehood, of sovereignty, of territory. So I think that's what we sort of agree on, or the sort of embedded, or something that we share. And before this panel, the four of us, and also Alexandro, we were having lunch and talking, and some of the things came to me as sort of shared struggles as people who are from sort of semi-peripheral or peripheral states, including, for example, we are all trained. Well, forgive me if I'm wrong, but most of us are trained in the American European tradition, and then also, we're seeing more and more students from our countries, from our regions, going to European American central places, intellectual places for their legal education. And it is from there that, for me, it's particularly interesting that we, as much as we're trained in the Western approach, we ended up thinking something different. And for that, I think was what Amanda was saying, the TWAIL approach, or also more broadly, the critical approach to international law and all those things. And for that, I'm grateful for the ones, older, senior ones before me, that has taken the steps in toward the TWAIL approach, or reviving the TWAIL approach and doing critical work. And that's all from my side. Thank you.
Okay, thank you very much. So we're going, we have just running out of time. We just have 7 minutes to go, but in any case, maybe we have time for one or two, I'm not sure, but maybe one question from the audience. Please go ahead. There will be an iPad, right? Written questions.
It is so boring.
Yes.
Someone said yes.
Okay, yes, someone is getting it. Okay, two.
Hi, I'm Clea Stradum. I'm from the Center for International Law Policy in Africa. And I want to respond to what George said about the language. We really try to stimulate and gather evidence and academic articles from Africa. And one of our biggest barriers is the language issue. Because it's easy to access English academic papers. Those are the ones that are usually highlighted, but they often follow a more Western approach, for example, from South Africa, where I'm from. And I'd like to ask, we've tried to look at mechanisms to really access more local languages, but also French and Portuguese, which is widely spoken on the continent. What would you suggest, or do you know of any mechanisms where it's easier to, because we've tried the process of approaching universities in different countries, saying, hey, we would appreciate if you sent us material. But then there's the problem of translation and the cost of that. And just what is your thoughts on making that more accessible?
Okay, maybe another very short question. Anyone? No?
Anyone has a quick?
So, anyone on the floor? Virtually or on site? Maybe, I don't know, Laurie?
There is another question, yeah.
Oh, okay.
Hello, thank you very much. My name is Tusa. I'm an attorney based in DC. I just had a quick question about different steps that potentially Western powers can take to reconcile potential past interventionism in different countries. I know that Germany, Great Britain have made some steps to reconcile a potentially controversial past in select countries with current policy, and whether those are good approaches and a potential avenue for reconciliation. Thank you.
Okay. Okay, I think that maybe 30 seconds for each one of you, or I don't know, anyone that should be interested in, could be interested in engaging on those questions.
Okay, I'll take the language one. You know, nowadays so much knowledge is produced, articles published, that very few institutions can sort of gather, you know, all of it. I think Max Planck Institute in Heidelberg probably kind of tries to do that, but they must be one of the very few. I think it's this kind of getting access to some of this stuff. It is a problem of real world, but it's a minor problem in the sense that, do we actually use this stuff? Do we, once we have it in the shelves, the stuff in other languages, our research culture, our culture of thinking, debating international law, how you know, how much do we ask that, you know, for example, as editors, that in terms of sources of an article, could it be that this conversation is only between Western scholars writing in English language? That should be the central question. And once we start to see, and why is it a problem? It's a problem because it doesn't necessarily reflect on what goes on in the world in large. That's why it becomes a kind of problem. It gives a distorted picture. So I think collecting this stuff is important, collected what is said about international law in different languages, but starting to use it is what it comes, what is most important.
Shall I jump in?
Yeah.
Thanks for both questions. So about the first one, I don't have an answer to your very specific question. I don't know if new softwares are making this easier or not. I have no idea. Maybe drop it. I actually read recently something that was written in German and translated algorithmically into English, and it was fine. So maybe that's. But I think also, I'll jump on what Laurie was saying. I think also in English-speaking or kind of English-speaking academia and practice, we need to also rethink of our standards of competence and of what counts as an authoritative statement, right? Because I think part of the story there is that if we said, you know, we will be concerned if you're writing about Russia without speaking Russian, someone might learn Russian, or someone might start having a collaborator who speaks Russian, right? And that's the other thing of also, and the same would apply to African approaches and so on, right? I could not imagine, I've written a little bit about Ukraine, and I've written it with a colleague who's Ukrainian and native Russian speaker, because to me, it's not just a matter of optics. It's I don't think I can say something very authoritative without, right? So if editors, and in general, we start, and I'm not saying, everything that doesn't sound 10 languages should be rejected, but at least start from a position of suspicion, right? I think, and that could perhaps also force collaborations between North-South and between North-North and South-South collaborations that are useful. The question about reckoning with colonialism, so one way to do it, of course, it would be to bring it within the realm of international law, right? Because Germany has said in all possible formulations that what they're doing has nothing to do with legal obligations, and what they're giving is not reparations, is developmental aid, right? So bringing it within the realm, I think it is within the realm of international law, but at least stop resisting the fact that international law does have things to say, not always great things to say about colonial harms, but I think it has some things to say, and stop resisting that this is a legal relationship apart from a moral, a political, and a historical relationship would be a good first step. And then we can hash out the details, right? That's the first step. It won't solve everything.
Okay, thank you. Amaka just asked, we don't have more time. I mean, it's 3:30, but Amaka, in 30 seconds, she could intervene on the second question. Amaka, please go ahead.
So with regards to the second question, I agree with Dina, and also I have to say that there is really not enough that can be done to restore and to repatriate what the colonial harm that was caused centuries ago. There is nothing that can be done. In fact, asking that means creating a whole new world that this cannot provide, right? How do you pay for thousands of lives that have been lost? But as Dina said, we can start by the language we use, right? The language of admitting that harm was done. The language, for instance, of Germany admitting that what it did in Namibia is genocide. It's the language of even Britain and France admitting what they did in Haiti is genocide, is crime against humanity. That language, currently, there are frameworks within international law that's allowed for that language to be used and to allow for a restoration or a justice, some form of justice, right? But it starts with us, it starts with these countries using the right language to begin with.
Okay. So unfortunately, we don't have more time. It's 3:32. Well, I would like to thank all the panelists for their presentations. It was really, really stimulating. As I said at the start of this event, it was quite an honor to chair this panel. I just would like to thank also Professor Alejandro Shetman, who made all possible efforts to convene everyone here, including me, to put me online. So I'd like to thank him in person. Maybe in the future I could thank you in person, Alejandro. So thank you very much, everyone. I hope you have a very good event. Next panels. Thank you.